It's a pleasure to be here at AEI and a pleasure to be here with Judge Kavanaugh, who is really the star of this show. I'm just the facilitator. I am not a lawyer. I do not play one on TV, though sometimes I do in the newspaper. So Judge Kavanaugh will soon celebrate his 10th anniversary on the D.C. Circuit Court of Appeals. It's hard to believe it's been that long, where he has become one of the nation's most consequential young judges. He's a graduate of Yale Law School and was a law clerk to Justice Anthony Kennedy. He's also worked in the executive branch as an attorney in the Solicitor General's office, an associate counsel in the Office of Independent Counsel, and as an assistant to the president and staff secretary under President George W. Bush. Since he's been on the D.C. Circuit, Judge Kavanaugh has also taught at Yale, Harvard, and Georgetown Law. And given his age, his intellectual rigor, his dedication to constitutional principles, and his distinguished judicial record, I think it's safe to say he will be one of the half dozen or so judges who will be considered for the Supreme Court by the next Republican president, assuming, of course, there ever is another Republican president. And speaking of sorry for the gallows humor there, and speaking of the Supreme Court, we meet at, as Gary said, a very propitious time, given recent events, the death of Justice Scalia and the great Justice Scalia, and the nomination of Merrick Garland to replace him. I want it noted for the record that Judge Kavanaugh did not cancel his appearance here, which is previously scheduled after those events, though he certainly might have. First question, which I have to ask to retain my standing in the journalistic guild. What do you think of Judge Garland's nomination?
Well, thank you to AEI for being here. Thanks to Gary and Paul. And I will answer the question. I think Chief Judge Garland is a brilliant jurist. He is a good friend of mine. He is a great chief judge. He's thoughtful. He's considerate. He's collegial. He works well with others. He's a good man, great integrity. And he is supremely qualified by the objective characteristics of experience, temperament, writing ability, scholarly ability for the Supreme Court. Obviously, questions about the process of what's going on and the direction of the Supreme Court and what role judicial philosophy should play in the confirmation process are really above my pay grade. And thus, I can't comment on how that should all proceed, nor would I know what to say about how all that should all proceed given the different circumstances. That's not my role. But as to the person and the judge, I have nothing but the greatest respect for him. He's been a great friend to me. He's been a role model to me in how he goes about his job. He has a wonderful work ethic. He's a good man.
All right, high praise indeed. So in one of your speeches, you wrote, or essays, which I have been through, you suggested that every judicial nominee should get a vote, up or down in the Senate, within 180 days. You said that you wrote that within 6 months, that ought to be enough time for the Senate to consider somebody's record and vote. Do you still believe that in the case of Judge Garland?
So what I believe is that the rules of the road should be set in advance. I've been working on this issue since 2001 when I was an associate counsel in the Bush White House. October 30 of 2002, after a number of Bush nominees, Miguel Estrada, John Roberts, and others, had not received hearings, President Bush gave a speech outlining a process that he proposed that the Senate agree on for consideration in a timely manner of all judicial nominees, Supreme Court and lower courts,
right,
and that there be an up or down vote on all nominees within 6 months. And I think that was a great proposal. Now, what it requires is both sides to come together and agree that these are going to be the rules of the road in advance. And as we know, nothing happened with respect to President Bush's proposal. It's something talked about for years afterwards. It echoed something President Clinton had said when he was president. It's a bipartisan problem in the lower court level of judges not getting hearings and votes. At the Supreme Court level, of course, the proposal would apply to the Supreme Court as well, but it really requires the rules of the road to be set in advance. And my whole purpose in talking about that at the time, and I've talked about it repeatedly over the years, is that the wrong time to think about these issues is in the middle of the crisis or the nomination or the debate, because everyone has a vested interest in how it turns out. The time to consider these issues and a whole host of structural issues with respect to our constitutional processes is in advance, to agree on the rules of the road in advance of the crisis so that they apply, as President Bush said, no matter who is president and no matter which party controls the Senate. I still think it would be great if the Senate got together at some point. Obviously, it's hard in the middle of a nomination, but at some point, and agreed these are going to be the rules of the road for lower court judges, for Supreme Court justices. Timely votes, timely hearings. What's the vote standard? Is it 60 votes or 51 votes? That's really another one that's above my pay grade, but it should be set in advance. It's set now for lower court judges at 51. What is it for Supreme Court? Is the nuclear or constitutional option, depending on how you want to phrase it, going to be invoked for that in the future? My big point is set the rules of the road in advance so that we don't have the situation we're in.
So both the leaders on the Republican and Democratic side would come together in a neutral corner and agree to set these rules of the roads in advance going forward for all nominations.
That's the ideal. Now, I'm a realist.
That is optimistic.
I have lived in the real world, but I don't give up my idealism either. And my idealism is that our system of government works better when you can set rules of the road for how processes are supposed to work in times of difficulty and crisis. And you think about these things ahead of time, and you don't have a vested interest necessarily in how they turn out.
We haven't had a Supreme Court justice filibustered a nominee in a long time, but I think we may be heading there. Would your advice to the Senate be, let's make the standard 51 votes or 60?
So that's up to the Senate, but I think that should be set in advance and adhered to no matter what. And I have said publicly before, I said it a while ago, that I can surely imagine the nuclear constitutional option, in other words, the change from 60 to 51, happening for the Supreme Court. I think that's likely to happen at some point. Why? It's already happened for the lower courts, so why wouldn't it? And happen for the Supreme Court at some point in the future if it's already happened for the lower courts. Now, they could get together and agree, no, that will not happen. But again, it requires both parties to think about it in a neutral corner, as you put it. It's difficult to do in the time when there is a vacancy.
All right, so let's get into some substantive judicial issues of the current moment. You've described yourself as an originalist, much as Justice Scalia did. And you describe yourself as looking, and you do, in your opinions, looking at the text of the Constitution and of the statutes and putting those to the forefront of your analysis. Where do you think originalism stands right now in our jurisprudence after Justice Scalia's tenure on the court? Has it made advances, or is this going to be, with Justice Scalia, a relatively short detour judicially?
Well, let me say first about Justice Scalia, that he was a hero to me and so many others, and how he went about his job, in his courage, his principle, his passion, his humor, his clarity. All those things are models and have been models for all of us. And he has been, as Justice Kagan said last fall at the Scalia lecture at Harvard, he's been one of the most consequential jurists in American history, no doubt about it. And his basic idea was pay attention to the words of the Constitution and pay attention to the words of the statutes that Congress passes. A very simple and easily conveyed idea, but it shows how far the Supreme Court had strayed from those ideas before Justice Scalia came on the scene. As Paul Clement said famously in one oral argument, answering a question, well, in the bad old days, and someone said, what were the bad old days? And it was Justice Scalia asking the question. He said, the bad old days were before you came on the court, Justice Scalia, which was a good way for Paul to answer the question. In other words, there was not attention paid to what the words of the document said, what the words of the statute said. And I think that effect that he had, he didn't achieve everything he set out to achieve, but he achieved a whole lot. And I think it will have a lasting impact for generations, centuries, in terms of paying attention to the words of the document. Because the role of the judge, quite simply, as he put it, is not to make the policy decisions. The role of the judge is to interpret the laws that have been passed by others, either in the Constitution or in the statutes, and to interpret what the policymakers themselves have done, not to change just because we think what they did might be mistaken, to our own preferred positions. And that was the idea that he stood for, he fought for, and he achieved in many areas of the law. And I think that will have a lasting impact.
Do you see the influence of originalism, or some people describe it, its complement as textualism,
Right.
in the current Supreme Court, even among some of the more liberal justices?
I think all of the justices pay attention to the text of the statute. Again, to cite Justice Kagan at the Scalia lecture, she really emphasized this. She said, we're all textualists now. That was Justice Kagan saying that. That shows the influence, I think, that Justice Scalia had. And what she meant by that, as she explained, was that all of the justices start in statutory cases with what's the text of the law passed by Congress. There's not the kind of dismissive behavior towards the text of the statute that there was in prior decades on the Supreme Court. So I think all of the justices do that. Now, they have different views of how stringently they're going to stick to the text, and that's where they're disagree, how they apply certain canons of construction. One of the big issues, which is pretty in the weeds, but is how quickly do you find ambiguity in a statute, which then allows you to turn to various canons of construction. I think that's a huge and very difficult question, and one that does divide the justices. And then in the constitutional cases, of course, you start with the text, but there's whole bodies of precedent on all of these areas, or most all of these areas of constitutional interpretation.
All right, I want to get into an area that you've really focused on and has become a hot issue of debate in recent years, and that is judicial analysis of executive regulations, executive branch agency regulations, and interpretation, implementation of statutes. Your opinion in a dissent in the Coalition of Responsible Regulation versus EPA, you wrote the following. To be sure, courts must be wary of undue interference with an agency's actions, implementing its statutory responsibilities. But undue deference or abdication to an agency carries its own systemic costs. If a court mistakenly allows an agency's transgression of statutory limits, then we greenlight a significant shift of power from the legislative branch to the executive branch. So, pungent words. Have courts been too deferential, in your view, to the executive branch in assessing regulations in recent years?
In a word, yes. I think courts have been too deferential, and it really stems from expansion, I would say, of the Chevron doctrine, which is the idea that when the statute is ambiguous, the court will defer to the executive branch's reasonable interpretation of the statute. And I think courts have been a bit too quick to find statutes ambiguous, to go back to the point I made earlier about the debate about how ambiguous must the statute be in order to trigger Chevron deference. And I think courts have not done a good enough job in enough cases of sticking with the words of the statute that Congress passed. Chevron itself has an important footnote, footnote 9, that to really get in the weeds, it often gets overlooked, about courts are supposed to apply all the tools of construction to the statute and figure out the best meaning of it before they engage in the step of deferring to the agency. And sometimes that exercise gets overlooked, I think, by courts, or doesn't get sufficient attention. The bottom line is, when Congress passes a statute and sets the boundaries, it's our job, I believe, as courts, to make sure that we police those boundaries in a case, justiciable case, when someone has standing. So, when we don't do that, what we're allowing the executive branch to do, and this is a bipartisan issue, this is not a partisan issue. Republican administrations and Democratic administrations push the envelope with their agencies. Our job is to hold fast to the line that Congress has drawn and make sure that we police it. Again, not undue cramping of the executive branch, but try to figure out what the line that Congress drew, and then hold fast to it. I should say, the reason executive branch agencies do this is, of course, because presidents run for office on policy agendas. They don't run through New Hampshire and Iowa and Wisconsin and all the states and say, when I get into office, I'm going to make sure that the agencies all carefully hew to the law. You know, that's not a platform. You're running for office on health care and immigration reform and on economic issues. And when you get into environmental protection, when you get into office, you want to get either new legislation passed, or if you can't get new legislation passed, get the agencies to exercise their rulemaking authority to achieve your policy objectives to the extent permissible. And that to the extent permissible becomes really the battleground. And so the agencies have a tendency, and it's understandable, to push the envelope. And Chevron really encourages that, because an agency might say, well, can we get away with this? Is it really legal? And well, it's ambiguous. Okay, let's go for it. That kind of rationale. And that's where I think the courts really have to step in. Again, a bipartisan issue. I don't think this is a partisan issue at all. The court's job is to hold true to the line that Congress set forth.
Chevron, 1984 precedent, Chevron versus NRDC. You mentioned the two-part test. How ambiguous is the statute?
Yes.
And then how reasonable is the interpretation by the agency if it is ambiguous?
Yes.
And then the tendency has been, if it seems reasonable, then the agency gets its way. Is it time to revisit Chevron?
Well,
And if not overturn it,
right,
in whole, at least rein it in and put some barriers on it?
Well, I think it should be reined in. Part of it is just applying that. Again, I hate to cite a footnote, but footnotes are where all the important things are sometimes buried in Supreme Court opinions. Footnote 9 of Chevron, faithfully applied, does rein it in a significant degree in and of itself. And significantly, I think the Supreme Court has expressed skepticism about Chevron in recent years. Under what circumstances does it apply? Interestingly, in the King versus Burwell case last year, Chief Justice Roberts' majority opinion, in the course of saying that the statutory interpretation was permissible, did go out of his way, and this is a six-justice opinion, to say that Chevron was inapplicable in cases of great significance. I'm paraphrasing there, but major questions kind of cases. And that leads to the question, well, this doctrine that we've had for so long is inapplicable in the really important cases. What kind of doctrine, why is it now applicable in the less important, but still important cases? And I think we're going to have two problems as lower courts. One is, what's the line between those major cases and the less major cases that are still significant, and when Chevron applies? And then I guess this will be above our pay grade and for the Supreme Court to consider, but if they've drawn this exception and they've drawn some other exceptions to Chevron, what's the state of the doctrine in general as an analytical whole at this point?
Well, I noticed that in King v. Burwell as well, but I also detected, even in Justice Scalia's opinion in the utility group versus EPA opinion, not an explicit rejection of Chevron, but kind of walked around it rather notably. And he has been one of those, had been one of those of the Supreme Court who'd been most frequently cited Chevron in some of his own opinions.
So I think a doctrine like this, and it makes sense when Congress uses words like reasonable and appropriate and feasible and practicable, those kinds of words in a statute that are often in statutes. We want to give agencies, Congress wants to give agencies room to make decisions. But when Congress sets forth a specifically worded statute, then courts' job is to enforce that statute as written. I think what Justice Scalia observed, I don't want to speak for him necessarily, but I think what the opinions reflect is over time, the phenomenon I described, which is agencies pushing the envelope more and more, became apparent to judges, and I think caused some discomfort. And what that leads to is things like King versus Burwell of the court saying, well, we're just not going to apply Chevron in this case. Okay. There you have it. It's not going to apply because they're not comfortable in a really significant case saying, we're just going to defer to an executive branch's agency's interpretation.
So you're a student of the separation of powers, and I would make a normative statement here and see if you agree, that when the courts do not adequately police the executive agencies when they're interpreting statutes, it can corrupt Congress and the executive. Congress in the sense that it causes them to say, we're going to write even vaguer statutes and punt to the executive, which we can then blame if we don't like the rules they write. And the executive, because the executive then says, all right, we have free rein to write the regulations we want as we want them or as the president wants them. Do you agree with that?
I think it's hard to generalize about the effects on Congress on all this, because Congress is 535 people and there are different statutes in different areas where they do this. I think what happens oftentimes in Congress is there is disagreement about something and they can't resolve it, and the compromise sometimes is to punt the issue to the agency. And if they do that through broad, capacious terms, our job is not to interfere with that decision. Sometimes, however, the compromise in Congress is to draw a line, maybe an in-between the line between the two positions, and then the agency wants to go beyond the compromise. And that's where the court's role is to step in, I believe, and police that line for to protect the Congress and to perform our role in the separation of powers. I want to make clear, it's a balance always for the courts. We can't be unduly interfering with the proper operation of Congress and the executive branch, but at the same time, what I think has happened is perhaps undue abdication in some of these agency cases. But there are cases, I just want to emphasize, where it is appropriate to allow an agency room to make policy decisions because the statute gives them that room to make the policy decision. And in those cases, it would be improper for us to jump in and interfere with that.
Okay, thank you. Now, a related issue that has been much debated in this administration in particular is the suspension of the laws. That is, the president's decision not to enforce either certain laws or parts of laws. Two examples: the marijuana provision of the Controlled Substances Act related to Colorado and Washington, which passed referenda legalizing marijuana, and of course the immigration statutes and the deportation elements of immigration law. How much leeway does a president have, in your view, to not enforce statutes?
Right, so I want to distinguish two categories here. There are statutes that regulate the executive branch, Freedom of Information Act, Anti-Torture Act, acts that regulate executive branch officials and how they conduct their business. On those statutes, the executive branch has a duty to follow the statute unless the statute is unconstitutional, in which case the president can state a constitutional objection and someone with standing can bring the case to court, and the courts won't have the final word on that case, whether the president's right or Congress is right about whether that statute regulating the executive branch is unconstitutional. But absent a claim of unconstitutionality, the separation of powers, as I understand it, requires the executive branch to follow that statute. There's a separate category, body of laws, the primary body of laws that regulate private behavior, that prohibit drug possession or drug distribution. Those kinds of prohibit bank robbery, prohibit certain kinds of dumping of illegal substances into streams or waters. Those kinds of federal laws that are ubiquitous, that regulate private behavior. And the question is, to what extent can the president or the executive branch say, we're not going to enforce a certain category of those laws because of policy disagreement, because of resource constraints, because of constitutional objections. And I don't mean to punt unduly, but I tell my students every year in separation of powers for the last several years, I think that's one of the great unanswered questions of constitutional law. And why is it an unanswered question? Oftentimes it's difficult for someone to have standing. Okay, I'm not going to enforce the certain kinds of drug laws. Well, who has standing to challenge the president's or the executive branch's decision not to do that? That's a difficult inquiry in many cases as well. So it doesn't. It's a hard question to answer. One of the things to think about, because I've written different things about this, kind of tiptoeing around different parts of this, the pardon power. So how does that relate to prosecutorial discretion? Today, the president has the raw constitutional power to pardon every federal offender. The raw power. It is right there in the text of the Constitution. And if that's true, and it is true, to what extent is the president, the executive branch, required at the front end to bring charges against someone in categories of cases where the president thinks, well, I think they should be pardoned. I don't think these laws should be enforced. So Akhil Amar, the professor at Yale Law School, brilliant scholar, has written, and I've found this worthy of attention, what's the relationship between prosecutorial discretion and the pardon power? And I think that's a tough question as well. So I think it's unanswered. I think it's difficult. Certainly, resource constraints are a traditional justification for prosecutorial discretion. Okay, we have a limited bank of resources here, so we're going to focus on serious drug crime, serious economic fraud. We're not going to focus on certain kinds of cases, and that traditionally has been a justification. The theoretical question, but maybe also a real question, is what about when you have plenty of resources? So that's not a justification, but the executive branch says, we just don't think it's appropriate to be penalizing people for a certain kind of behavior that is illegal under the statute that Congress has passed. That is a very challenging question. Again, remember the pardon power, though. So there is the raw pardon power at the back end to say, we're going to pardon everyone who's been convicted of a certain class of offenses.
But the suspension of the laws in this administration, Congress has found itself frustrated in checking that when it has objected. And part of the problem is the issue you raised of standing.
Right.
Because you have to have an injured party, and the Supreme Court tends to take and certainly under Justice Roberts, a pretty tight definition of standing. So, for example, in the case involving the marijuana laws, we had a case that was the states of Oklahoma and Nebraska appealed to the Supreme Court to say, would you take, we've been injured by the fact that Colorado is not enforcing the marijuana laws, so it's spilling over into our territory. We have to expend law enforcement resources to deal with drug gangs and so on. And they appealed to the Supreme Court, and the Supreme Court did not take the case, though Justice Thomas issued with Justice Alito concurring, a rather pointed dissent saying they should also take it. Now, if I look at your cases on standing, you have suggested that the Supreme Court should look at perhaps broadening, and correct me if I'm putting words in your mouth, broadening its definition of standing in a way that when you have a clear injury, take the case, or they have a right to their day in court.
Yeah, that was in one pocket of standing jurisprudence, so-called zone of interest standing, and the Supreme Court subsequently, I think, did narrow the restraints that it had imposed on standing based on zone of interest standing. More broadly, I think standing jurisprudence is, I haven't suggested more generally expanding standing beyond what the Supreme Court has said. But I think it can be difficult to apply to particular cases. Who is an injured party in a particular case? What kinds of injury are good enough to make it a case or controversy for purposes of Article 3 of the Constitution and to bring it into court? I think that's historically been a very difficult area of Supreme Court jurisprudence. And to what extent do states have standing? That, of course, was an issue during the Bush administration in the Massachusetts versus EPA case, where the court ultimately found that the state of Massachusetts did have standing in a case involving global warming. To what extent do states have standing more generally to challenge effects of decisions made by the executive branch that have impact on state citizens or on the states as sovereign? That's a pretty challenging area of Supreme Court jurisprudence right now. We may get more guidance in the near future or may not. These things tend to be dialogues over years rather than resolved for all time in one sitting by the Supreme Court. So we will see how that transpires.
All right, let's turn to another area of the law. This is the debate over, sometimes even among conservatives, over the gun cases in the Second Amendment. McDonald, as you know, it was the case which incorporated the Heller decision to the states. And Justice Alito used substantive due process under the 14th Amendment in his 5-4 majority opinion. But Justice Thomas wrote that he would have used the Privileges or Immunities Clause of the 14th Amendment, which in an oral argument, Justice Scalia had dismissed as the darling of the professoriate as an analysis.
I don't think he meant that as a compliment.
He did not mean it as a compliment, though. And at the Journal, we have people on both sides of that question. So, what's your view about whether? And as you know, the relevance of this is that there are some libertarians,
Right.
who want to revive the Privileges and Immunities Clause as a way to, which has basically been considered by many scholars a dead letter since the Slaughterhouse cases of 1873, I think. But they want to revive it as a way to protect individual liberty under the Constitution. Where do you come down on this?
So the case in question concerned incorporation of the original Second Amendment against the states. And with many of the constitutional amendments in the Bill of Rights, of course, the Supreme Court over time, under the guise of the 14th Amendment, had decided, okay, yes, the First Amendment protection for freedom of speech applies not just against the federal government, but against the state governments. Sixth Amendment right to counsel not just applies in federal cases, but also in state cases. The 14th Amendment, whether it's through substantive due process or through the Privileges and Immunities Clause, really analytically, in the end, doesn't matter which home it has, but the court over time had incorporated all of these rights against the state governments. The Second Amendment, that had not happened yet until the McDonald case. And the question really was, are we going to treat the Second Amendment like these other amendments in the Bill of Rights that have been incorporated against the state governments? And the court concluded, yes, we are, because there's no reason really to distinguish the Second Amendment from the other amendments on that basis. On the question of unenumerated rights generally, I think one of the important things for judges to do is to enforce the rights that are in the Constitution. And we're not supposed to just abdicate and let Congress and the president interpret them. That comes from Marbury versus Madison. Interpret them by themselves without any judicial role in cases or controversies. We enforce the words and the rights that are in the Constitution. What about rights that are important, we think, but aren't in the Constitution, explicitly at least? And the court has struggled with that. The test that usually gets bandied about, whether you call it privileges and immunities or substantive due process, is a test, well, the court will recognize unenumerated rights that are deeply rooted in the nation's history and tradition. A case called Glucksberg articulated that test. Now, how do you apply that to particular rights? At what level of generality do you define the right to figure out whether something's rooted in history and tradition? That's been the battleground in the unenumerated rights cases. I don't think, whether it's substantive due process or privileges and immunities, there's some new font for courts to go around, font of authority for courts to go around and create a bunch of new rights that we think ourselves are important. I think we need to stick to what the Supreme Court has articulated as the test for unenumerated rights, which is deeply rooted in history and tradition. Otherwise, courts really will become politicians or political policy-making bodies. Oh, if this right's important to me, I'm going to find it in the 14th Amendment. Well, the certain other right's important to you, you're going to find it in the 14th Amendment. This is, Judge Bork, of course, railed against that kind of judicial creation of unenumerated rights willy-nilly. And that's something that I think the Supreme Court itself has largely respected. Certainly the test it applies, deeply rooted in history and tradition, is a test that respects or envisions a narrow judicial role. And I think a narrow judicial role is appropriate in that kind of case.
But there has been criticism for finding a right, the gun right, for individuals in the Second Amendment after 200 years of the court not having discovered that right in Heller. J. Harvey Wilkinson, Richard Posner, and others have suggested that that was in fact an example of activist conservative judging and finding exactly the sort of enumerated right that conservatives like, and that's not what Judge Bork or others might have done.
Well, the difference is between unenumerated rights and enumerated rights. And the right to possess arms, keep and bear arms, is right there.
But the liberal justices in Heller said, actually, it says those rights are for a militia, not for individuals.
Right, and that required analysis of the text and the prefatory clause, and that's one of Justice Scalia's landmark majority opinions. One of his finest opinions, of course, was the careful analysis of the text and history of the precise words of the Second Amendment. And what I think is interesting on that point about Justice Scalia and about the court in that case is all 9 justices did a heavy textual analysis. To your point about his methodology having a lasting impact, that's what they all did. They disagreed about how to interpret that prefatory clause, but no one said, who cares what the words say? They all went deep into the words, and that really was a legacy of Justice Scalia, but that you could see it right there in all 9 justices. Now, he disagreed very much with how the 4 dissenters interpreted those words, but he certainly would have applauded the methodology of them looking at the words.
So going forward, I was struck in McDonald, which followed Heller and incorporated it in Second Amendment interpretation of Heller into the states, that the 4 liberals didn't give any ground. They held very, very firm, and in fact, whereas they might have said, look, since Heller is established precedent and we've incorporated all of the other rights into in the main Bill of Rights to the states, we should go along here. And maybe they could have even influenced the majority opinion in a way to say, here's the possibility for more gun regulation under the Second Amendment. Instead, they didn't. They stuck very firmly against incorporation, and suggests to me that that maybe Heller is in some peril if the justices change on the court. I wonder if you agree with that.
I don't know. Is the short answer. In terms of Supreme Court, that case, McDonald, and what the dissenters did, it's a tough thing for a Supreme Court justice to decide on something they really disagreed with, but the majority went the other way, when to reconcile yourself, if ever, to that majority opinion. And on some issues, you will say, okay, the court has so held, and move forward accordingly. On some issues, and I think this is true of every justice in modern times who sat on the court, you just can't get there, ever. And you continue to dissent and continue to say that decision is wrong and should be overruled. I will point out there was a Second Amendment case a couple weeks ago about stun guns, where at least in a 2-page opinion, all the justices applied Heller to a particular Massachusetts case. I don't think that case is huge significance, but it was an interesting data point in the discussion about Second Amendment going forward. You know, one of the areas that's been difficult in the Second Amendment is, yes, there's an individual right, but to what extent are regulations of arms, of guns, permissible under Heller? And Section 2 of Heller is all about why there is an individual right. Section 3 is, okay, what exceptions to that right will we allow, in Justice Scalia's majority opinion? And on that, he really used a history and tradition-based test, laws that had traditionally been in place to allow certain kinds of narrow regulation of guns would be permissible. The question in many lower court cases since then has been, what's the appropriate test to apply? What kinds of other regulations are permissible? And that's been a real battleground in some of the lower court decisions since Heller. I thought Justice Scalia pretty clearly said what the test is, a history and tradition-based approach to figuring out any exceptions. I've been a lonely voice, I will say, in reading Heller that way.
Are you surprised the court hasn't taken many more Second Amendment cases since Heller? Because some have moved to the court and they haven't taken them. This is individual jurisdictions that have passed gun regulations that have been challenged for violating Heller?
I don't know. I guess I don't know all the dynamics that go into an individual decision to deny cert and what the strategic behavior might be on particular cases or just the approach. I think that's one of the difficult things from the outside to analyze is when the court decides to grant cert and decides to let something percolate, to use the language that's often used, and to see more lower court decisions before jumping back into a controversial area. I think it's obvious that the court doesn't like to continually jump into controversial areas. It often can't avoid it,
right.
But to the extent it has some control over its docket and can at least manage how often it gets into something that they know is so nationally and locally divisive and divisive on the court, I think they're careful about doing that too often.
All right, another area involving the Bill of Rights, free speech. Your opinion in Emily's List versus the Federal Election Commission struck down federal limits on the amount of money that nonprofits can spend on campaign speech. Mm-hmm. This would suggest to me that you have some sympathy for the Supreme Court's jurisprudence on campaign spending and speech, such as Citizens United. Is that a fair inference?
Our job in the Emily's List case, I thought, was to apply the Supreme Court precedent as it existed. Do I agree with the whole edifice? If we started back in 1976 with Buckley versus Vallejo, I don't know where I'd even begin to analyze that question. But I think the court itself, and certainly my job in Emily's List, was to figure out where the court's jurisprudence led on a question like that. And the question, it seemed to me, that the court's jurisprudence led to the idea, which our court subsequently confirmed in the Speech Now case and in-bank case, was that outside groups have an ability to express their views about issues of the day and in support and opposition to candidates. And to express your views, you have to raise money to do that. And that, of course, is what our court held unanimously in bank in the wake of Citizens United in the Speech Now case. Now, the Emily's List was before Citizens United, so I was analyzing even the case law before
right.
Citizens United to reach that conclusion, but I thought that's where the court's jurisprudence led us. I'll say one thing about the campaign finance jurisprudence is there's clearly a structure that has been set up as a result of the jurisprudence where the political parties and candidates can't raise large sums of money and outside groups can. And particularly I don't envision the court going back on the candidates part of that in the near future. But on the parties question, the parties have much less power to raise money now than outside groups. And this is really since 2003, not a surprise that outside groups therefore have a much more prominent role in our political system today than they did when parties could raise a lot of money. Now, you can say it's good or bad that the parties have less power vis-a-vis the outside groups, but that is a reality, I think, and it's a reality directly attributable to the Supreme Court's jurisprudence, which has maintained the limit on contributions to parties, but has not allowed limits on contributions to outside entities. And I guess different groups of justices would resolve that disparity in different ways. Some would eliminate the caps on contributions to parties. There was a case that went up there from our court where the court summarily affirmed the existing jurisprudence 6-3, and it was Justice Kennedy, Justice Scalia, and Justice Thomas who dissented in just a short order from the decision not to take that case up on the merits. That was really, should we now allow the parties to raise the money again, overrule that part of McConnell. As of now, the jurisprudence seems stable for the moment, at least through this election, stable in the sense of outside groups can raise unlimited amounts, parties cannot.
But do you agree with the trend of the Supreme Court's jurisprudence that money spent during campaigns does represent speech and therefore deserves First Amendment protection, or at least strict scrutiny of any limits on that spending?
Absolutely, yeah, that's what the Supreme Court has said, and certainly I said pretty emphatically in the Emily's List opinion. I think political speech is at the core of the First Amendment, and to make your voice heard, you need to raise money to be able to communicate to others in any kind of effective way. And so I think that's lies at the core of the First Amendment.
All right, I want to open it up to the audience. If anybody has any questions for Judge Kavanaugh, I'd love to hear from you. Thank you. Yes, ma'am. Do we have a microphone? We do. Coming up.
Thanks for all your presentation. It's a very good, great session. But I think about a judicial system, and once I really heard Judge Ginsburg when she was in the lower court, she is scolding at the plaintiff's attorney that he didn't do the job. And I also in a different state court, the judge is saying that this jury trial demand, they should be go to a circuit court. But so for all this, I'm saying that in the court, the problem is not just for the judge to make a good decision, but the court administration, whether they do the job or not. Because a lot of time, they don't accept the filing of the case, or even a case decision, they don't allow them to have the court file or transcript or tape. So I just wonder, can the judges do a better job to make an investigation of all this, not just their own case, but the whole system-wide? So the normal citizen, they don't have to say, have a decade-long litigation, and try to the Supreme Court and then go down, but go nowhere and not even have remedies and no.
So I think you raise a good question about access to courts, and this is one of the things on the, not the jurisprudential side, but the administration side of the court system, federal and state, we are all strive to do a better job of, which is making access to courts affordable and making it consumer friendly. And there are 50 state systems out there in the District of Columbia, and there's a whole federal system. But we, on the federal side, I know, work hard at trying to ensure access to the courts and fair, expeditious, efficient resolution of cases. I don't think we achieve that objective as well as we can and should, but we're always striving to do better, and so too, I think, are many state court systems.
Gentleman in the rear.
Thank you. Judge, what is your opinion as to when the Supreme Court justices should, let's say, overrule stare decisis? And it seems to me that liberal judges have no qualms about doing so when it suits their purposes, but that's maybe just my biases on this. Is there a criterion which one could use as to when the court should overturn a decision which at least the majority feels has incorrectly been decided?
Right. So I think justices of all stripes agree that stare decisis is important, but not an inexorable command. It's not inflexible. It's not absolute. And if it were, well, you would have some horrible decisions still on the books, Plessy versus Ferguson, overruled in Brown v. Board, and many others. So the court, it is appropriate that the court overrule precedent in certain circumstances. It's also appropriate, in my view, and the court has said many times, that stare decisis be the starting point. You can't reinvent the wheel necessarily every time you confront an issue. The question then is, and the hard question is, when is it appropriate and when is it not? And I would love to have a perfect answer to that question. To my point on the first question, setting the rules of the road in advance, which is a general thing I think about in everything related to jurisprudence. I think it's really hard to have a set formula for overruling that's going to work in all cases. And to speak in common parlance, when it's really wrong and has really significant practical effects, and there hasn't been reliance interests of the kind you would have with a property or contract decision, that seems to be a descriptive of when the court will overrule something. But is that a formula that binds? Is that a formula that tells you in advance with justices of different stripes when to do it and when to not? Not really. I just think that's when it happens. Really wrong and really significant from the viewpoint of the justice's practical significance, and not a case where there's specific reliance interests. I would love to have a formula. You know, to go to idealism versus realism, one of my goals, which is probably unachievable, but doesn't mean I shouldn't strive for it and seek to have all of us strive for it, is that judges from a variety of philosophical and policy viewpoints could agree on jurisprudential methodology. And we do on large numbers of cases, but then there are some where obviously we don't. And stare decisis is an issue where there is a formula, but it's not one that I think gives much predictability or guidance to particular judges or that binds in a way. And so it leads to the criticism that you articulated. I think you could go to a different crowd across town and find the exact same critique in reverse, because everyone thinks the other people are doing it in a less principled way than they're doing it. So that's one of the problems with the stare decisis doctrine. I'm not sure it's solvable, but I'm going to keep trying.
Can you think of a case that deserves to be overturned?
Yes.
Would you volunteer one?
No.
Pending confirmation hearings. Yes, sir, right here.
Thank you very much.
Actually, I'm going to say one. Morrison v. Olson.
That's the independent counsel statute case.
It's been effectively overruled, but I would put the final nail in.
Here, here.
Thank you, sir. I had two quick questions. One was, you said some very nice words about the Chief Judge, Mr. Chief Judge Garland, and about his nomination process. But of course, then you talked about Heller and your uncertainty about whether Heller could survive a challenge, whether the individual right to bear arms itself could potentially be overruled. That was only a 5-4 decision. Chief Judge Garland, of course, has a history with Heller, and it's not encouraging. So he had a history both on the en banc issue as well, you know. So is it, in your view, a valid issue for Republican senators to consider whether a man who may be perfectly suited, temperament-wise, and very qualified would potentially overrule one of the most important achievements of the justice he would be replacing, ironically? And the second thing is, I just finished a 5-year stint on Capitol Hill. I was a congressional investigator. And one of the observations I have is that Congress is further and further losing ground to the executive. When we were, Mike, the committee I work for is currently in litigation with the executive over documents. And when Congress is in a battle with the executive, I think the agencies have gotten so powerful, and the executive has basically run roughshod over Congress, that once Congress has essentially given up the power of the purse as its weapon, it has nothing left. So my question to you is do you think there's a role for the courts to try to restore a little bit of the balance, or are we just going to see executive expansion for the rest of time?
So on your second question, the courts are limited to resolving cases and controversies. We don't have a free commission, a roving commission, to go out and try to get things right in the balance between the branches. In cases or controversies, sure, our job is to, as I've explained, to apply the statute as written and to, in separation of powers cases, historically, starting with Marbury versus Madison, but Powell v. McCormick, or the recess appointments case, or the Free Enterprise Fund case, the court's role is absolutely to dig in to make sure that what Congress is doing is consistent with the structure set up in the Constitution. But as far as a broader commission, I don't know where to begin in terms of some of the things you're talking about. Of course, the power of the purse is the most powerful. On Chief Judge Garland, I'll reiterate, he's an excellent judge and an excellent man. In terms of judicial philosophy and how that should play into the confirmation decisions and what role the Senate should play in considering and how they should factor in judicial philosophy, that's really for the Senate to consider the direction of the court, all of that. And that's been a debate, of course, throughout our history, what the Senate's proper role is in the confirmation process and how to do that. So I leave that discussion of judicial philosophy and direction of the court to the Senate and the President in that process. And I was talking about my experience with a friend and a colleague, Chief Judge Garland.
We're running out of time, but we have a gentleman here against the pillar, right there.
Thanks. Elon Werman with Winston and Strawn. My question is on the suspending power. I wanted to go back to that because it is sort of a rallying cry for many constitutionalists, and you answered with some discussion on prosecutorial discretion. So I'm wondering if there is an important difference, a qualitative difference between the two, in the sense that when the president exercises prosecutorial discretion, a private actor engaging in acts that are unlawful knows that the law applies to him. It may not be enforced against him in a particular instance. He might get lucky. Maybe the Fed's resources are exhausted. But he knows that there's always a risk that the law applies to him. Whereas the suspending power, by definition, says there's this whole class of laws that no longer applies, not because it was repealed through bicameralism and presentment to the president, but because the president says...
It's really a question of, can you do categorical prosecutorial discretion? And I think that's one that's been done in some instances historically that people can point to. It's usually justified by resource allocation as well as some policy discomfort, or there's a widespread belief a certain kind of law is past its prime, so to speak, and there's no real controversy about not enforcing it anymore. So I think that is an unanswered question. I think, again, you look at the pardon power as a potential source of how to analyze it, but you also look at the text of the Constitution, take care that the law be faithfully executed. And I think it's, as I said, I think it's a great unanswered question. I think it's difficult to get an answer to. I've been teaching separation of powers for 10 years, and I've been trying every year to get an answer, and I feel like I'm further away now than I was when I started in thinking about getting an answer on that. That question in particular I view as a very, very challenging question of constitutional law.
We have one more question. Gentleman right here.
Good afternoon, Your Honor. I'm Daniel Shapiro, a 1L at George Mason University. And I was just wondering, when it comes to judicial deference to agency interpretation, are all agencies created equal, or should there be maybe a different standard for agencies involved in foreign policy, national security, intelligence, along a Curtis Wright deference line of inherent presidential power over like the federative authority and foreign policy?
So I think the answer to that is there isn't a qualitative difference in the deference that's given, but Congress tends to write statutes much more broadly and flexibly in the national security and foreign policy arena. Not always, and there too, when there's someone withstanding, which there often isn't in those cases, but when there's someone withstanding, I do think our job is to hold fast to the line that Congress has drawn. The Curtis Wright case, the dicta in that, which was cited, I think, was like a macro in the Justice Department. You cite it in every case for the last 60 years. The Supreme Court in Zivotofsky basically threw that aside in a couple paragraphs and said, don't cite that dicta from the old Curtis Wright case any longer, which was, as you suggested, an idea of giving even broader deference to the executive branch. I think there, as elsewhere, in a justiciable case, if Congress has set forth the boundaries, there's someone withstanding, there's a case or controversy, it's not our job to blink. It's not our job to be scared. It's not our job to be cowed by the executive. Think about the Youngstown case. Think about Marbury versus Madison itself. Think about United States versus Richard Nixon, not a national security case. But some of the most important, I'd say, landmark cases in Supreme Court history are where they stood firm against the political branches, upheld the Constitution and the rule of law, including in cases involving the president, the Youngstown, including in national security cases, the Youngstown case being the landmark, and one to this day is still very influential in lower courts and in the Supreme Court.
I want to thank everybody for listening. I want to thank Judge Kavanaugh. I think you got a good sense of his richness and depth of his jurisprudence. Thank you very much.
Thank you.
Thank you, sir.
Okay, Adam, over to you.
Thank you, Gary. Well, it's a tough act to follow, Paul interviewing Judge Kavanaugh, but it's a real pleasure to be here today to speak on these issues and moderate this panel. And it's a very fitting place to be for this discussion. In his remarks, Judge Kavanaugh referred back to Justice Kagan's comments that Justice Scalia was one of the most consequential jurists in American history, and that's true. And I think it's also worth keeping in mind where Justice Scalia got started on so much of his work, here at AEI. When he left the Ford administration, but before he went back into academia, he spent time here. Even after he went back to the University of Chicago, he continued to edit Regulation magazine and stayed very active in AEI. And when you go back and look at what he was writing at the time, even before he was on the DC Circuit, you can see him begin to work through these issues of constitutional law and structure. And he did so alongside Walter Burns and other really great constitutional thinkers. So really couldn't think of a more fitting place to have this conversation today. Let me begin by briefly introducing our speakers, and then we'll get right into it. On my far right is John Eastman. He's a senior fellow at the Claremont Institute, where he's also founding director of the Institute's Center for Constitutional Jurisprudence. And at the Chapman University's Fowler School of Law, he is the Henry Salvatori Professor of Law and Community Service. And given the subject matter today, I wanted to point out that during the Supreme Court's 1996-1997 term, he served as a clerk to Justice Thomas, and so he had a front row seat for the Clinton v. Jones case, in addition to other cases. Second, sitting to his left, is Jeremy Rabkin, professor of law at George Mason University School of Law. Before joining the Mason faculty, Jeremy was for 2 decades a professor in Cornell University's Department of Government. And he's not just a presidential scholar, he's also an appointee of both Presidents George W. Bush and Barack Obama, both of whom appointed him to serve on the U.S. Institute of Peace's Board of Directors. So, Jeremy, you represent bipartisanship on this panel. And then finally, sitting to my right is Kevin Walsh, professor of law at the University of Richmond School of Law, where he teaches and writes on the federal courts and on constitutional law. His scholarship focuses on doctrines that define the scope of federal judicial power. During the court's 2003 to 2004 term, he served for the late Justice Scalia, a year marked by the Supreme Court's decision to uphold the McCain-Feingold campaign finance laws in McConnell versus FEC. Now, all three of our speakers are prolific scholars and writers on the constitutional rights and structure, and the relationship between the court, the Supreme Court, and the rest of American government and democracy. So it's a real pleasure to welcome them here today for this discussion. So let's begin with Professor Eastman.
So I was going to talk mainly about how to put in or restore constraints that the founders envisioned on the courts, but the conversation just over the last hour leads me to add a kind of slightly different topic to my remarks as well. And that is, I think, a profound transformation in Justice Scalia's thinking in recent years on this doctrine of deference. And I think it's important to frame the question of how we got there, how he came of age as an administrative state lawyer, reacting against the activism of the Warren Court in the 1960s, the creation out of whole cloth of new unenumerated rights, and then using those newly created rights to strike down otherwise perfectly valid and legitimate exercises of legislative power, either by the federal Congress or by the state legislatures. And so in reaction to that, Justice Scalia and a lot of other people of the age developed even the terminology against judicial activism. And that seemed to only hit one half of the coin of the problem of the judicial role, because it's judicial activism to make up a right and use that to strike down an exercise of power. But it's equally judicially active, or more properly, more precisely, a measure of judicial abdication, not to strike down acts of Congress or the state legislatures that exceed their constitutional authority or violate actual enumerated rights. And I think the transformation in Justice Scalia's thinking on deference doctrines, and many of which he himself had authored and then in the last couple of years called into question, I think was a realization that this other side of the judicial role, the judicial coin, needed to be brought back. And I want to start there because I think it helps frame the other discussion I wanted to have, which is, has the courts gotten out of control? Alexander Hamilton famously called it the weakest of the three departments of power. It's hard to imagine modernly that that's true. I mean, every single issue great and small, seems to get decided by the courts these days rather than by the political branches. It's hard to say that it's the weakest branch that has neither control of the purse nor the sword. They seem to have claimed for themselves control of both the purse and the sword. So what did the founders envision as this institution? Would it be unchecked in the way we've come to see it? Whenever they make a pronouncement, does that now become the supreme law of the land? And I think the evidence from the founding is exactly the opposite of that claim. Yes, they wanted an independent judiciary that could withstand majoritarian tyranny, infliction of threats to individual rights. It needed to be separate from the political process and independent for that. And they built in a lot of independence to the judiciary. Life tenure, or we always say life tenure. It's not life tenure, I remind people. It's tenure during good behavior. So judges that are not acting in good behavior, watch out. And good behavior didn't mean just not committing some blatant felony from the bench. It meant undermining your role as a judge in the separation of power system we have. That was the height of the high crime and misdemeanor that for a public official to take. So there was this degree of independence, but it was checked. Hamilton, there were two checks on it, kind of three maybe. One is Hamilton tells us they depend for the efficacy, even for the efficacy of their judgments on the enforcement of other branches. What does that say? Well, if it's a bad decision, the executive doesn't even have to enforce it. That's a rather dramatic check on the power of the judiciary that we've completely lost sight of. The other set is it would be a full account for a judge that exceeds their power, that exercises will instead of judgment, that tries to impose their views on policy instead of merely interpreting the law. It would be a full answer in the provisions of the Constitution dealing with the impeachment power. Right? And then the other check we have is the kind of front-loaded check, is the president's power to affect the direction of the courts over time by his nomination of judges and by the Senate in their role in the confirmation of judges. So all of those things were at least envisioned by the founders to be part and parcel of an independent judiciary that would not itself become a runaway judiciary, that there were these checks at the outer limit on what the judiciary could do. Well, what's happened in the 200 years since? Why have those checks envisioned by the founders not worked? Well, part of it is, I think, Thomas Jefferson's overreach in the Samuel Chase impeachment, right? Probably an impeachment for raw partisan political grounds rather than real impeachable grounds. And I think when the Senate backed away from that precipice, that pendulum that Jefferson tried to push that far then swung all the way over to the other direction. Judges are untouchable in the impeachment process for anything they do on the bench. Only for outside criminal conduct will they be subject to impeachment. And that completely removed the salutary check on their authority that I think Hamilton and all the rest of the founders envisioned. And I think if we're going to restore the notion that the judiciary is not an unchecked branch of government, we've got to somehow revive that. Even if it's hardly ever used, the fact that it might be would certainly have salutary effect. The second thing I think comes in a philosophical change in our understanding. Right, and a change in our understanding of what Marbury versus Madison, the very famous case itself, was all about. Remember, Marbury's often touted today as the judges have the final word. They're the supreme. Whenever they say anything, it's the supreme law of the land. Right, and we even use it in our rhetoric, criticizing or objecting to Supreme Court decisions we don't like. Say, well, they've spoken, so it's the law of the land. Well, it's not the law of the land. And if you go back and look carefully at Marbury versus Madison, John Marshall confronted this very issue, said if the judges get to strike down an act of Congress or challenge an executive action, doesn't that make the court supreme to these others what are supposed to be co-equal branches? And Marshall goes out of his way to say, no, that's not the case. All three of the branches must be obedient to the Constitution and to the people that ratified it. That's the supreme law of the land. And when I'm confronted with a statute and with a constitutional provision that is contrary to it, my obligation as a judge, just as the obligation as the legislature or the executive, is to give effect to the higher law of that Constitution, because we are all bound by it. That claim is not one of judicial supremacy, but of judicial equal humility to the governing and binding authority of the Constitution. we lose that about 100 years later. You know, the famous thing, the Constitution is the law of the land, but it is whatever the judges say it is, right? And that means, in fact, we even had decades when constitutional law textbooks quit having copies of the Constitution because they had become irrelevant by the 1970s. Whatever the latest pronouncement out of that oracle up on First Street was the supreme law of the land. And it's this philosophical change in our understanding of the Constitution versus the role of the court in interpreting the Constitution that has made it hard to check excesses of the court. And so I think we need to get back to using the right language in those terms as well. So those are the main things I want us to think about when courts are making it up, finding new unenumerated rights, using it to strike down validly enacted, otherwise validly enacted pronouncements of the supreme authority in the land, which is the individuals who are the sovereign authority that created the Constitution. Are we going to restore any semblance of the checks on that runaway judiciary? And I think if we don't, we're going to find ourselves regrettably in the position that Abraham Lincoln predicted way back in his first inaugural address. Right? If we're going to take as dispositive pronouncements of the Supreme Court on contested issues when they've resolved it in a particular case, we will have ceased to that extent to be a self-governing people. And I think it's high time that we start questioning this claim of judicial supremacy in order to get the balance right, back restored to what our founders envisioned. Thanks.
Thanks, John. Jeremy?
Can I just talk? Yes, of course. Okay, I apologize if I sound a little hoarse. I'm still struggling with a cold. I just want to start with something very concrete because power, policy, and self-government is kind of vague. Not complaining. Just,
Duly noted.
when 5 justices of the Supreme Court decided that the Constitution required same-sex marriage, that really, I think, with all respect to Judge Kavanaugh, I think that showed you that Justice Scalia's influence was not as great as many of his fans had hoped. There was no textualism there was no nothing there. That's what 5 liberals on the court wanted to do. I think people they have not really assimilated the scale of the challenge that poses. I mean, this was a real act of not just lawlessness that they do every day, but I mean, social vandalism, right? It's basically saying what had been understood in Western society for the last 2,000 years, and arguably, if you go to the same-sex part of it, the last, I don't know, 100.
First book of Genesis.
No, actually, I was going to say since one of the ice ages when people came out of caves and said, okay, just like, it was astonishing that the court thought it could do that, and it's equally remarkable that people said, oh, well, and we just moved on. I think that just puts into focus that the court has the potential to be extraordinarily disruptive. And if that's not your issue and you're not worked up about that, let me just remind you that Roe v. Wade, apart from the immediate tragic consequences in people's lives, is extremely disruptive to national politics. And it's the main reason why every time we have a nomination to the Supreme Court, certainly by a Republican president, there's intense politics over who is that person, where does that person stand, and mostly it's cranked up over how's this going to affect the majority on the court over abortion. That is not something which we've experienced through American history. That is something which really has come about since the 1970s, and it has more to do with Roe v. Wade, I think, than anything else, and it's really sad. There's so many things about that which are sad. I think it is a very plausible view, one which I am actually rather sympathetic to. The court's bad decisions have been so bad, so destructive, so costly, that we'd be better off without a court that had the power to do these things. We'd be better off with nothing, at least regarding so-called enforcing the Constitution, than this court that can just sort of lurch into some extreme crazy thing on its own, just because the New York Times thinks it's a good thing. That seems to be entirely plausible. That seems to be entirely reasonable. As my long ago dissertation advisor James Q. Wilson said, it's just like peace in the Middle East. It has everything going for it except feasibility. If this were on the menu, just strip the Supreme Court of its power to declare statutes unconstitutional, I would say yes, vote for it, but I think that's not on the menu. To the contrary, with the thing which is, I think, kind of amazing, we live in an age which is supposed to be an age of, democratization and populism and communication and mobilization. You see not just the institution of courts, courts with constitutional authority, but rather activist courts gaining momentum across, I was going to say across the Western world, even in some non-Western countries, but just to start with Western countries. The Canadian Supreme Court is a very activist court. Courts in Europe, very activist. Of course, the European Court of Justice, very activist. One of the remarkable things is the Court of Human Rights in Europe told the British they had to reconfigure their system of government because it seemed to be violating the separation of powers. Somebody from Albania, somebody from Norway, somebody from Cyprus says the mother of parliaments is not perfectly configured because the House of Lords has some judicial authority, and Tony Blair said, oh, sorry, okay, we'll fix it. And so they established for the first time this thing called the Supreme Court, and they removed any judicial role from the House of Lords, right? That self-abasement in front of just a bunch of people in Europe calling themselves a court is really astonishing. The Tories did complain. They said, oh, that's wrong. This court is too interventionist. They were also provoked because later on, the European Court of Human Rights said Britain couldn't, it not only couldn't deport people who might have problems with persecution or their families, so it was terrorists, but it couldn't discriminate against them. So if they couldn't be deported, they had to continue to receive government benefits. So Tories said this was outrageous. But meanwhile, there's been a Tory government without a coalition. They have their own majority in Parliament. Have they said, now we're enacting legislation to remove the authority of the European Court of Human Rights? No, they haven't. And just from reading the British press, it appears the reason they haven't is that's too controversial, because people in Britain think, oh, our rights wouldn't be secure if we didn't have the European Court of Human Rights. So we live in a world in which people think your rights are more secure if somebody, even an Albanian, even a German, nothing against Albania, but I mean, like, just an arbitrary collection of foreign countries will send judges to watch over you, and that's better. I mean, seriously? But yes, that's a very powerful force. So let me just briefly say, what should we do? Because Adam posed that question. I don't have much to say, so I can do it in 2 minutes. I think it's good to emphasize the text, of course. I think it is good to emphasize responsible jurisprudence, which is, cautious and careful. But still, I think libertarians have a point that judges ought to have some, as they say, sense of engagement. And I want to just tick off 3 reasons why I think that is good. What we're really arguing about under that heading of engagement is enforcing things that are in the Constitution, like property and contract rights and liberty. If you are reticent about those things, which the Supreme Court has mostly been in the last 75 years, you are basically playing to the notion of the left that those things aren't important, and what's really important is autonomy, and most of all, sexual autonomy. And then if that doesn't quite cover it, you get into some crazed spiritual rumination that Justice Kennedy offers up as the Constitution. People actually know what property is. People know what contracts are. People know what being able to conduct your life on your own is about. If you give that up, the Constitution becomes something mystical. So I'm for doing more of that. And I want to say finally, I think it was a better country when more people felt more legal protection to order their own life and understood that pretty much they had to pull up their socks and figure out what they were going to do, and not expect as much from the government, and certainly not so much from the federal government. I think it's a better society if you have protections for ordinary human activities, such as starting a business, such as buying property, such as building a house, and not having the EPA pounce on you and say, wait, that's a little damp there in your front yard. It could be a wetland. You're suddenly subject to federal controls. And I'm not saying that to be either mocking or sarcastic. I mean, the court has tended to be not to treat those things seriously because they're not in the same category as Justice Kennedy said, finding your place in the universe. But if you own the land and you wanted to build there, it's kind of important to you. Thank you.
Thanks, Chairman. Kevin, and before you start, I just wanted to say I introduced you as a law professor, but on Twitter you referred to yourself as an academic lawyer.
Right.
So if I've done sort of ill justice to your reputation, I apologize.
Well, I mean, that is intentional. I've actually given a lot of thought to what does it mean to profess law? And that's a hard question, actually, in a world. So I was 16. I was 16 years old when Justice Scalia wrote his dissent in Planned Parenthood versus Casey, which I think is inspirational to a whole generation, really. And he took on this idea of judicial supremacy. And it's interesting, how do you teach constitutional law when you're trying to explain that judicial supremacy is not the law? Because this course in constitutional law, the normal course, is a series of Supreme Court cases. So I try and do different things. Whenever I write to my students, I say, good morning, good evening, students of the Constitution and of constitutional law, right? To highlight that this is a distinction that matters. And I think the Reagan Justice Department did an excellent job of highlighting that. And so I actually want to pick up where the two who went before me left things, which is with this idea of judicial supremacy and Obergefell. Because I was ready to quit my job if the Chief Justice didn't dissent in Obergefell. And who knows if that would have happened. But think about this and how far things have come, actually, since Roe versus Wade, which preceded me in the universe. 4 justices, led by the Chief Justice of the United States in that case, okay, and the Chief Justice on the bench, from the bench, said the Constitution has nothing to do with this. And he says, who do we think we are? Okay, and if you read those dissents, they're much more powerful and more sophisticated in terms of ideas and jurisprudence than the dissents in Roe versus Wade. And Justice Scalia's legacy, I think, is one, he didn't count on the fact of a vote, he counted on his ideas. So I think if we're going to say, what do we do now about judicial supremacy, there's 3 things. One is, first, to recognize where it comes from. It's not just about the judges claiming power for themselves. That's easy, but I think that's a caricature. We have judicial supremacy also because it's very convenient for our political leaders and public officials. Okay, so it's very convenient to have the court decide all the hard issues. If you want to know who is most relieved in Washington, apart from the winners in Obergefell, it was the Republican officials because their coalition was fracturing and they didn't want to take responsibility for it. So much easier to have a court that does this and to run against the court rather than take responsibility for self-government. And I think there are political foundations to judicial supremacy. The second is there's jurisdictional foundations to judicial supremacy, right? The court has jurisdiction that Congress gives to it, Okay, there's the only jurisdiction that's constitutionally required is the original jurisdiction of the Supreme Court. The rest of it is given by statute. The Supreme Court didn't invent judicial review in Marbury versus Madison, right? It was presupposed in the first jurisdictional statute, the Judiciary Act of 1789. So Congress has given this authority to the court. Now, why does this matter? Something we don't think about very much is what shapes the self-conception of the justices on the court. And I think an underappreciated cause of the inflated self-conception that they have, and sorry, this can be a little obscure, is the Judiciary Act of 1925. If you haven't heard about it, it's not because there's a conspiracy, it's because federal jurisdiction is boring. But that's the, it turns out that's the time when they received almost unlimited discretion to decide what cases they wanted to hear, okay? And once the court has agenda-setting discretion, okay, that is where will can come into it, okay? Think about Marbury versus Madison. The power to set aside a law, right, is part of the judicial duty to decide a case. Now they get to decide what they want to decide, and they can sort of manipulate different things using that power. So this leads into what do we do? What do we do now? I actually think there's some serious thought should be given to taking away some of the agenda-setting discretion that the court has. This is counterintuitive in some ways, but make them do more work. Don't let them just pick the cases don't let them be just big picture people. Set up some categories of cases where they have to take review and decide things like the rest of judges do. So there's different ways that you can do this. One option might be whenever a state is asking for review. Another option might be to make certification from appellate courts more mandatory. There's ways that if we really wanted to, we could change the rules of the game perfectly constitutionally, give them more to do, and that way they'll have less time to muck things up. So that would be my suggestion.
Well, thank you. Before I start in with questions and then open it up to our guests, does anybody have any specific responses to anything that's been said so far?
It's a good thought.
Yeah, I mean, I like that. The notion that anytime a lower court strikes down an act of a state, then that's not part of the discretionary docket, but part of the mandatory docket. One of the recommendations I had back when Senator Cruz held his hearing last summer on ways to constrain the runaway judiciary was to reflect on the expansion of federal power that came out of the Civil War amendments. Salutary effect initially, but it's created a much greater transfer of power than anybody. And combined with the 17th Amendment removing the states from a direct say in the federal government, there's nobody in town now checking the combination of the federal legislature, the federal executive, and the federal courts when they're intruding on the states. And so giving the states some greater role, even beyond just a mandatory review, but a state override of Supreme Court decisions that intrude on federalism. It would be hard to accomplish, in any given case, but the fact that it would be there might help shift that balance back a little bit as well that we lost with the 17th Amendment.
The impetus, I mean, for thinking about actually, if you think in terms of football, right? One way that you can do a defense is to blitz, right? And so you rush the court rather, and it shows respect to them by you're not replacing their job. But if they have to go on record, it's a lot easier to overturn a case from 40, 50 years ago than it is from 10 years ago. And if you think about, so I'm down in Richmond, so I'm a Virginian now. And when you think about what happened to our marriage laws that was struck down by the Fourth Circuit, more or less at the invitation of the Supreme Court, and then they couldn't even be bothered to hear the case from our state or from several other states. And I think that sort of, we wash our hands of it, is offensive to our constitutional jurisprudence. And so, if you can identify a small category of cases then they'd be more like judges. I think another idea would be they should spend some time on the circuit courts. I think that's a little bit harder to do, but we have the Fourth Circuit that sits down in Richmond, and one of my friends was arguing, and you find out your panel the morning of argument, and he had Justice O'Connor on his panel, which was great. If you're a lawyer, that's kind of fun. And then he read an interview with her about a month later where she talked about just how it's kind of boring and tedious to be hearing cases just like the one my buddy argued. And I thought,
Good.
boring and tedium is good. You're a judge, right?
Well, she's not. She retired. I don't know why she even sits, but that's another question.
So anyhow, that's one thought. But this is the problem, though, is although there are jurisdictional foundations, I think the political foundations part is tough. That is, Congress would have to act, and they might not want to.
Oh, Jeremy?
No, I'm.
Okay. Well, as we were looking ahead at this event and we saw that Judge Kavanaugh was going to be speaking, I took a little time to go back at some of your own writings, Judge, and one point stuck out at me, and I think it's a good lead-in for the first question. You said at your confirmation hearing, I want to be a federal judge because I know from experience and through my upbringing the role of the courts in protecting the rights and liberties of the people. I know how essential the rule of law is to our country. I know how the independence of the federal judiciary is central to our constitutional form of government. Now, just as we've seen in the remarks between John and Jeremy especially, we see this sort of bubbling debate, especially on the right, about what some are calling now judicial engagement, right? An alternative to what some would call judicial activism or judicial restraint, this point that you made, John, that it's time for courts to lean in more on some cases. And I'm curious, is this a real tenable distinction, judicial engagement versus activism and restraint? I'd be curious for all the panelists' thoughts on whether this is a good idea on the right.
Well, I mean, I think there's an easy case and there's a hard case. The easy case is Congress has power to regulate commerce among the states. And when they regulate things that are not commerce and that are not interstate, they've exceeded their authority. And we expect the courts to strike down that act because it is contrary to the power delegated to them in the Constitution. Mm-hmm. Call that judicial engagement. Much more difficult when they, exercising a power given to them, do something that is inappropriate and improper, right? Madison would say taking property from A and giving it to B. I don't know, say payments for contraceptive mandates from the employer to the employee, right? The very definition of justice. Let's assume it's within one of the enumerated powers given to Congress to regulate health care. That was my first point. But let's assume that it is, and there's no specific Bill of Rights that prohibits that. Is it activism or the appropriate role for the court to strike down that because it's against a fundamental principle of justice? This is the Lochner question. And the greatest regret in some of the recent decisions I have is when they're challenging Congress's authority, they treat Lochner as itself persona non grata case, Justice Roberts, Justice Scalia, when in fact I think the founders would have understood that question also was part of the judicial obligation. The tough part is how you draw the line from that and distinguish it from raw Brennanism and Planned Parenthood versus Casey and those things. And that requires a level of sophistication that we haven't seen in a while at the court, but I do think that line can be drawn.
Jeremy?
That was good enough.
Okay. Kevin?
Well, just in response to the idea, I mean, again, we look at what their jurisdictional grants are. They can decide cases under federal law, not under natural law. And yet, right? So I think it's very important to understand that actually probably the role of natural law is to underwrite the moral obligation of judges to respect the positive law. And so, there's different judicial engagement means different kinds of things. I'm neither for nor against, since I don't know exactly what it would be. But I'd say when there's law to apply, the judges should apply it. And the hard part is if you think about, say Obergefell, where did the federal law on point come from, right? So when we have a living constitution and you can sort of make things into federal law, then this distinction sort of collapses, and it becomes remarkably easy. One thing I try and do is remind people that the federal courts are part of the federal government. They exercise government power, and it's a power of a particular government. So if there's real federal law, go ahead and apply it, but not natural law.
Since I'm here with in part a hat on from the Claremont Institute, let me defend the natural law point of this, and I think this goes back to the part of the discussion that Judge Kavanaugh had about the McDonald case, and I think it matters. Whether that case gets decided on substantive due process grounds, which is a kind of court-made-up thing, or privileges immunities grounds, which is deeply rooted in the history and traditions, the natural law traditions of the American founding, right? And to properly understand, to put it in textual terms, what that text meant requires that we have some understanding of that background tradition, just like we have to know what the Republican guarantee in the Maine Constitution is to give full effect to the text. And if the text actually tapped into that natural law foundation, a true textualist would understand what they meant by that text. By the way, I mean, this comes out very forcefully in a debate in 1818 in Congress over the admission of Missouri. You've got two constitutional texts, one that protects slavery and one that guarantees to every state a republican form of government, which is the antithesis of slavery. And Representative Talmadge, among others, gets up there and argues, we have an obligation to ensure that Missouri comes in meeting the requirement of a Republican guarantee. That means grounded in the consent of the governed. That means we cannot have slavery, which means rejection of the consent of the governed. And to distinguish that principle from the compromise with that principle that was the slave causes required that you tap into that broader tradition to give full meaning to the text of the Republican Guarantee Clause. So I don't have to treat it as kind of some platonic form out there in the air. They put it into the text of the Constitution itself, and if we would just give full effect to what they understood those words meant and what they were trying to codify, this dispute between Scalia and Thomas about natural law or not natural law would go away because they're both there within the text of the Constitution.
Now, even if we accept that this is the right way to interpret and apply the Constitution, as the philosopher Donald Rumsfeld said, you go to war with the army you have, right? I mean, with the court, as we've seen, not just as it currently consists, but going back decades, you know, can we trust that the army we have, the federal judiciary, you know, can we actually trust them to carry out the mission you have in mind?
Well, you know, Hamilton says in Federalist 81, if you got a problem with that, just impeach them all and start over again. I mean, you know, that's all right. Then you've got a different army and go forward with it. Look, what's always been most extraordinary to me in the abortion fights is that both sides argue from natural law premises. Neither of them argue from the text. Right? I have a fundamental right to the liberty of my body. You can't infringe it. That's not textual argument. That's a natural right fundamental argument. And the pro-life side argues that there's a fundamental right to life that can't be infringed and that must be protected. All right? And it's the same argument that existed in the 1850s. The slave owner said, the Constitution protects my fundamental right to property. You can't tell me I can't take my property to the new territories in Kansas and Nebraska. And Lincoln responded to that, said the other side is they have a fundamental right to their liberty. And the question is, which right is actually true? Which one is consistent with the notion of inalienable rights? And in both cases, one of them is true and consistent, and the other is false. And until we get a court that willing to kind of parse that question, we're never going to resolve the problem.
Jeremy?
So I want to say something just more modest. I mean, I'm kind of sympathetic to that, but I'm also sympathetic to the force of your question, which is, seriously, with the judges we have, your program is kind of ambitious. So let me, in a way, reformulate that. It's leaving a lot out, but still, it makes it seem a little more feasible. So my view of this is leave the 19th century behind. It was good enough. Leave the bad parts behind. By the end, it was pretty good. For a long time after the Great Depression, American judges, American writers on law, scholars, kind of internalized we had all these understandings about law which were suited to a different age, but what we learned in the Depression is that markets don't work unless there's really a lot of coordination and a lot of control, and people really need a lot of protection, because otherwise it'll just be, I mean, everyone will be worse off. So the government needs to move things along, and really judges can't follow that. So judges need to defer to experts who are regulators, and they will move things along. And that was a very, very powerful idea and a very plausible view in the 1930s and maybe in the 1940s and 50s. By the 1960s, people were like, wait, that's not right. I mean, people who weren't particularly ideological. Alfred Kahn at Cornell, I knew him, Mr. Airline Deregulation. He moved on from airline deregulation to, we should make people pay a fee to put their garbage out, because he was an economist, right? So he's one of the fathers of that nuisance of modern life, because he was just an economist. But he saw, wait, airline deregulation, it doesn't work. And he moved on to see that a lot of regulation doesn't work. And just at that moment, environmentalism came along and said, okay, well, maybe the economy could be okay with markets, but not the environment. To save the earth, we need a lot of protection and control, and so we're still living in that atmosphere. I would say, as a very simple, modest version of what you said, it'd be really helpful if courts could say, wait, taking people's property is bad. Sometimes it's necessary, sometimes it's justified, but it's presumptively bad, and we just want to see, do you really have good reason to do this? Interfering with people's liberty in just the ordinary sense, not the cosmic sense, but just like with new regulations, that's presumptively bad. So just show us that you have some reason for this. And I don't think that's like fantastically ambitious. Most of the time, they'll probably end up saying, oh, okay, yeah, okay, we see, yeah, okay, fine. But just accepting that statutes have limits, accepting that constitutional guarantees of liberty and property have some meaning, that's not utopian. And I think it is grounded in natural law, or at least a version of natural law. But if people are upset by the phrase natural law, let's just say old-time religion, the good old days, what we used to think. And it was okay. So you don't have to say, let's have a generation of judges who, really have the Claremont Institute training, right? It'd be enough to just encourage them to, could you try and protect people a little more in their property and their liberty? And the one thing that you can, I think, say is some of your colleagues will hate it. That's okay. You can have differences in the open, and maybe we'll make your colleagues a little more cautious when they start up other things. But it's good to establish that different people have different ideas about what needs to be protected, and we don't all agree, and okay, that's true, but it's respectable to be concerned about just basic things like trying to live your own life, as opposed to helping the government to refashion the atmosphere so that you feel more a part of society, which seems to be what the gay marriage thing was about, right? It was not about anybody's liberty. It was about, do you feel accepted? Well, rearranging society so that everyone feels accepted is like a really big undertaking. That's the one that's utopian.
Jeremy, I have to say, I'm impressed by your optimism that if we just stop saying natural law and start saying the word religion, it's something that everybody's going to rally behind.
Old-fashioned religion.
Old-fashioned religion, right. Kevin.
Yeah. So this is an interesting thing. I think
But people who used that expression, old-time religion, never used the phrase natural law.
I think that I am hopeful actually for our judges, because they're people of the law, and I think what we need to do is appeal to the nobility of sticking to the law and recognize how the currency of constitutional law gets debased as it becomes too easy to move around. Interestingly enough, I think that the best place to start with judicial supremacy and how it affects is with the judges themselves. I think you can make a case. You don't want to be supreme in the sense, there's law that governs what you do. There's the law of precedent, okay? There's the law of preclusion, law of judgments. And then there's the law of remedies. They don't necessarily need to or want to be, a fix-it. it kind of like, let's just make this whole thing work. They're watching, right? At least on the Supreme Court, and all judges are watching what's happening with the confirmation. And you say, well, I told you so. This is what you would expect. And I think that actually appealing to their self-conception, that would then recognize them limiting themselves. I mean, one of the greatest statements against judicial supremacy was what I mentioned in the Planned Parenthood versus Casey dissent, saying that there's actual law that governs the legal effect of what they do. So the case against judicial supremacy is a legal one. Judges can get that, and I think when they see the political forces pushing everything towards them. So, for example, I think they should realize that they were played, right? And they knew it in the Windsor case. So this was the case where they recognized that somehow they had jurisdiction, even though the administration was saying that what we're doing every day is unconstitutional, but we're not going to stop until the Supreme Court tells us. They agreed with the decision below, telling them to stop. But they said we're just gonna keep going, and avoid teaming up with the executive, essentially to give judicial blessing to essentially the change policy positions of an administration. I think judges can get that.
Well, about the confirmation process, and you mentioned earlier Justice Scalia's dissent in Planned Parenthood v. Casey. Just one last question before we start taking questions from the audience. In his dissent, Justice Scalia was very, very emphatic that if the court is in the business of value judgments, then he said, then confirmation hearings for new justices should deteriorate into question and answer sessions in which senators go through a list of their constituents' most favored and disfavored alleged constitutional rights. He said, at least we can have a sort of plebiscite each time a new nominee to that body is put forward. So with that in mind, I'd love your opinion on what should happen with Judge Garland's nomination.
Yeah, once you make the court into a policy-making branch, you not only are going to have nasty confirmation hearings that turn on the politics of the particular nominee, or more precisely on the politics of the person nominating him, but you're going to eventually start questioning why we have a court at all. Because if the court is just making the basic policy judgments, is it really consistent with the notion that basic policy judgments ought to be made by the citizenry, the ultimate sovereign, to hand those judgments over to unelected and unaccountable judges? And the answer to that is clearly no. And so at some point, this lack of regard to the judicial role that has come out of the judiciary, I agree that Congress was perfectly happy to cede that role to them. But it's a taking on of an authority that questions its own legitimacy in the long run, and I think we're seeing that increasingly in the nature of the confirmation hearings.
Yeah, I mean, judicial philosophy matters, and if you read Justice Alito's dissent in Obergefell, or if you read the dissent, perhaps this line stood out to you as well. Justice Alito talked about the decision as an indicator of the perhaps irremediable corruption of our culture of constitutional adjudication. And I have to say, I put a lot of stake in that, perhaps, right? And perhaps irremediable. I don't think it's necessarily fixed, but I don't want the court I don't want Justice Scalia's seat replaced with someone who's not an originalist, period.
So, Judge Kavanaugh said many wise things. I thought one of the wisest was it's really not the time to think about basic ground rules of procedure when you're already in the midst of a fight. It's kind of too late now to be thinking about what would be in general good ways of doing this. I thought the sensible advice, given the circumstances we are now in, was Mike McConnell's column in the Wall Street Journal. Press Hillary Clinton to say that she supports right. But she supports this nomination. If she thinks Merrick Garland is okay now, the Senate can wait to see the outcome of the election, and if she's elected, confirm him.
All right, well, we'll take some audience questions now, and as people are getting their hands up, I just want to say, in addition to the people who then Professor Scalia debated with at AEI way back when, was Robert Bork, and so we're very honored to have Mary Ellen Bork here today. All right. I see a question over there by the windows.
Andy Yuan. I specifically want to ask this question to Kevin Walsh, but anyone on the panel can answer. When you talked about the controls for controlling how the Supreme Court can set the agenda for the for what cases they review, don't you think that the power to grant cert to different cases is basically saying whether or not they agree with the lower court's decision, meaning that if they choose not to grant cert, it's acting as agreeing with the lower court decision? Because if you get rid of the power for them to set the agenda, then wouldn't that also make the lower court's decision less meaningful?
Maybe, maybe not. I mean, if they have to take a certain set of cases, the cases have to be brought there by lawyers, and the lawyers won't necessarily bring the cases there unless they think they can do better than what happened in the lower court. And so I think depending on who you empower to get off of the discretionary track, you may be able actually to have a sort of case selection effect that has. So, for example, if you're a state attorney general, and now a lot of these offices have become more professionalized, they have solicitor generals, very sophisticated about Supreme Court litigation. You might not choose so we're moving the strategy into sort of the political and legal actors there and outside the court. I'm not sure. I think that could have some substantive effects that would be desirable. And one other thing I'd say is when they have to decide more cases, that also could have effects on the content of the law, right? If they knew, for example, when they decided Obergefell that they'd immediately have to deal with all the consequences, right? And this is not a sort of conservative liberal thing. Same thing for Heller, right? If you knew when you decided Heller you have to figure out everything else because you don't have the choice of saying no, my guess is you have law-like decisions more on the front end because they realize, oh, we need to set some rules so that we don't keep having these things coming back to us. So
I like this. Between giving them much more work to do and having them ride circuit, you're taking the justice from philosopher king to harried business traveler.
And increase their pay. How about that? Yeah.
It's very generous.
So, more law clerks.
Other questions? Here in the front row.
My name is Li Yang. Thanks for your presentation. And I'm really concerned about our judicial system. Actually, I should be concerned about 3 branches. But what I mean is that there are a lot of abuse, a lot of, you can say, corrupts, and whether it is even an eminent man or something that is really misleading, is really abuse in a great extent. So I just wonder if we can think about all the problems. You can think about all the problems. Instead of the check and balance, they will be emphasized in some independent way, the way they ask people to think about that. And if you think about the ethic rule, we are thinking about Supreme Court now have a kind of super power beyond the ethic rule. And if we are thinking about all those corporate power or
let me take that up.
interest power, so I just wonder if you can really think about all those, make some concrete remedy or resolution to reform it.
We have about 3 minutes.
Yeah, so let me try. I think it's no accident that Alexander Hamilton ends the Federalist Papers in number 85, citing David Hume on this question. Says, we're putting together an entire system for an entire society here. It's great difficulty. No human genius is going to be able to get this right on the front end. Experience is going to guide our labor. Time must bring it perfection. And feeling of inconveniences must correct the mistakes. And so I think what we've seen over our nation's history, that the level of independence they first gave and then had accreted to the court has been too great. It has allowed the court to itself become unchecked in its exercise of power. And so we need to tweak the structure a little bit to get back some of the checks on that court that they envisioned. A revival of the impeachment power, I think, would be an important one. And but that's kind of like bringing a machete to a fine surgery. You don't want to impeach every judge just for bad conduct in a particular case. So maybe a congressional supermajority override of a decision striking down an act of Congress might help get that equilibrium a little bit more back in line. A supermajority of 2/3 would be hard to achieve. A simple majority of state overrides on a decision striking down state laws that intrude on federalism. That would be equally hard to do, but might have a very salutary effect on checking the judge's own temperament, even if it's never exercised. These are the kind of things that we ought to be thinking about to take seriously Hamilton's caution in that last Federalist paper that, you know, some of this stuff's going to appear out of balance over time, and we've got to be receptive to remedies that restore those balances.
Kevin?
I agree with the I guess where it's coming from, but I get nervous about, to me, I think about when John Marshall was at the Virginia Constitutional Convention. He didn't say much, but what he focused on, he said, you know, that an angry heaven will essentially deprive us of an independent judiciary, right? So when I think we do need an independent judiciary, I do think the appointments on the front end, the appointments process, the advice and consent and all of that is one of our structural features. On the back end, I wouldn't want to mess with their rulings necessarily, but I think what we have to do is reinvigorate truly judicial supremacy to get an understanding of what this awesome power that they have is. And I think making something like judicial review a function, once again, of judicial duty rather than judicial discretion, might be a good way without changing anything in our Constitution.
One last question of my own, I guess, and another AEI scholar I had in mind is Walter Burns. Right? He wrote so much about virtue and citizenship, and he actually looked to the courts in some of his writings as a source, as even a teacher maybe, of virtue in society. He said a liberal regime can't be indifferent to the virtue of its citizenry, and he quoted Madison and James Wilson, not James Q. Wilson, but Justice Wilson, in an essay in the Public Interest on the point that it was a problem that the court was getting government out of the business of promoting virtue and morality. And Alex Bickel, right, wrote about judges as possibly teachers of society, immersing themselves in the traditions and then helping the citizenry become the best version of itself. I mean, is there any role for that in the courts, or is that all past?
Well, at the very least, they should quit doing harm. So when the states are trying to exercise moral virtue and encourage moral virtue, to exercise their police power, the part that is not commonly quoted now, but the police power to help foster the health, safety, welfare, and morals of the people. This was one of the traditional functions of state governments. This court has said it's not only you can't advance it, but it is an illegitimate thing to be advancing. So at least get the foot off the neck. At least quit causing harm and let the states go about the task that the Constitution system allowed them to go about.
Kevin, Jeremy? Courts as teachers of men?
Yeah, I mean, think about the words we use to talk about judges that we admire, right? The word hero for Justice Scalia, for other judges. I do think that there is that what the Supreme Court does, right? There's a lot of teachable moments, but one of the things the judiciary does, I think one of the virtues is that we want to hold them to is, giving reasons for your things, answering other people's arguments, right? Showing your work. All of these things, I think, do teach a valuable lesson about our government, about how law works. And so I think, to the extent that you have opinions that don't do that, you're doing the wrong thing.
I'll say one thing. So I believe what you're referring to in Walter Burns, he several times cited this article by his friend Ralph Lerner, which was in the Supreme Court Review, called The Supreme Court as a Republican Schoolmaster. Right? And that sounds really inspiring, but if you actually go read it, what it's actually about is they had to go out on circuit in the early days. And in the course of riding circuit, they sometimes actually gave speeches to ordinary citizens who were assembled like for jury service. So it wasn't their inspirational opinions from the Supreme Court will inspire the nation. It was more like your suggestion. They actually went out to Kentucky and said, maybe you ought to think about this because the law actually works this way. And they looked at the audience reaction. They actually had to encounter ordinary citizens, which I think is not something they do very regularly these days.
Well, it sounds like a thinly veiled invitation for judges and justices to come to think tanks and talk about the Constitution. And so we're, again, very thankful to Judge Kavanaugh, Paul Gigot, and very thankful to AEI for hosting this event. And thanks to all of you.
Thank you.
Well, good luck. Thanks.